Welcome to the Meaningful Mediation Podcast, the place where leading lawyers and negotiators share their best tips and strategies for mediation and negotiation. I'm your host, Patrick Russell, a full-time Florida mediator and lawyer. My goal is to help you have an effective and meaningful mediation. Each episode will provide you with real-world strategies and tips to help you negotiate and mediate with confidence. Let's get to it. All right. Well, welcome to the Meaningful Mediation Podcast. This is the show where we explore the art of negotiation, persuasion, and dispute resolution with the sharpest legal minds. I'm your host, and today's guest is a trial attorney who has stood up to some of the biggest insurance companies in the country. He has tried over 40 jury trials as lead counsel and has been named as a top 40, under 40 civil litigator in the entire United States. He's also someone who believes that every case is a story waiting to be told. And I'm looking forward to hearing that. And he's a lawyer who also tells it best when he wins. So please welcome Ivan Abrams, founding partner of Abrams Justice Trial Attorneys in Miami, Florida. Ivan, welcome to the show.
Good morning, Patrick. Thank you so much for having me, and thank you for the introduction.
My pleasure. So before we dive in, as I've indicated earlier, you've been described as a natural storyteller. And I also saw something about a lion in the courtroom. So please tell me, which of these two things do you think matters most for a trial lawyer?
I would say 100%, telling stories. I think, we have to remember that at the end of the day, the people making the decision are going to be a panel of random jurors that come in with no legal background, don't really understand what's going on half the time. So how do you break things down in layman terms and, for example, take something that's kind of vanilla, like a contract dispute, and make it actually interesting and bring the individuals who are suing or being sued to life so that the jury can really get to know who they are, what they're about, and choose a side, the good side or the bad side.
Or is it possible sometimes they meet in the middle?
Certainly at mediation, at trial, I'm not hoping for a tie or something in the middle. I'm going for the gusto. But at mediation, You're 100% correct.
Well, this has been a common theme that I've heard a lot from trial lawyers is the importance of storytelling. And I assume this also applies to mediation. Do you agree?
100%.
And your audience there is a little different, though. Now you're talking to seasoned adjusters, professional negotiators. How might your story change, if at all, when at mediation?
I think it's important to always take a step back in mediation and put yourself in the other side's shoes. So for example, I do personal injury and then I also do business contract litigation. So both mediations and how I prepare and how I tell a story are very different. Obviously, the personal injury, it's very easy to learn about the victim, how they've been injured, how their life has been impacted, and convey that to the other side. In business cases, it's a little different. In the personal injury angle, I understand that adjusters probably may have 3 or 4 mediations in a week. So how do you differentiate your case from all the other cases that they hear about? How do you stand out in their mind and get your case, from the bottom of the pile to the top? And I think one way I do that is to try to be authentic and not necessarily put on a show, but show them that if this case goes to trial, this is what they can expect, the type of performance, the type of explanations, the story that a jury is going to hear. I don't like to leave anything to chance. I don't like to play games or make threats. I like to put it all on the table for them so they fully understand every angle, and trial is always a last resort, if that makes sense.
Sure. So what you're doing is providing them information and options. Either you can settle with this narrative or take your chances and see what happens at trial.
The one leverage that plaintiffs' lawyers have is that if the adjuster and the attorney for the other side are not going to come to a reasonable settlement, then we believe that if we go before a jury, they're going to give us a lot more money, right? I mean, that's the one leverage we have. We can either work this out together or we can use the jury trial process. And the only way to convince an adjuster and an attorney with 20 years of experience who do this every single day is to do the work before you get to mediation. And by that, I mean, take all the depositions, take all the experts' depositions, prepare your client so that when you step into the mediation room, you've already proven to the other side that you're one of those real trial lawyers. You're not one of those lawyers who's looking for a quick settlement and already focusing on the next case. I want the adjuster and my client who's there to believe that this is the only case I have. This is all that matters to me. And I'll take as much time as it takes to get the right result.
Well said. So you started your career as a Miami-Dade Assistant State Attorney. Walk me through that. What did prosecuting cases teach you about persuasion and negotiation that you couldn't have learned any other way?
Well, if I may, I don't want to take too much time, but I want to go kind of just a little step back, just so you can kind of understand me a little better. I didn't grow up in Florida. I grew up in Columbia, Maryland, kind of this project, very diverse community where I grew up around. My friends were all races, all ethnicities, all genders. And so I kind of grew up in an environment where I was comfortable speaking to anybody, right? I then went to undergraduate at Florida State University. And what's so cool about Florida State is they have an overseas program, to study over the summer. And rather than just partying and having fun, they offer internships. So my first legal job was at a mental health law firm in London in 2005, where my job was to take the tube maybe 5-6 hours a day, travel to all the mental health hospitals around London, United Kingdom, and meet with people when they've been recently arrested and been found to be suffering from some kind of mental health episode. So they'd be put in a hospital. And I would be the guy who'd be sent out to do the first interview. And of course, they'd hear my American accent and think, Tom Cruise is here to save the day. They've been given the best lawyer in the world. And I had to explain to them that I'm just the intern. I'm here to take their initial intake forms, etc. But that experience was powerful. At the end of every single day, I was exhausted. And when we would go to the pub with all the other lawyers from the firm, because that's the culture there, is to always go have a drink after work with your colleagues. I felt a sense of the first time in my life that I was actually making a difference, that I was helping people and, went to sleep every night feeling fulfilled. So when I came back from Florida State, I knew, okay, I guess I'm going to law school. This is something that I can do for the rest of my life. Applied to law school, went to Nova. And then through Nova, in your last year, some law schools offer this where you can get approved by the Florida Supreme Court to actually speak in court and act as a lawyer. So my first jury trial that I ever tried was as a third-year law student when I interned at the Miami-Dade State Attorney's office, and I got to do closing arguments, and it was just such an amazing experience. So for any law students or anyone, coming up in the legal system, if you can take advantage of the CLI, Certified Legal Intern Program, 100% do it. Because of that experience, this was right at the financial crisis in 2008, 2009, when people stopped hiring. But luckily, I'd kind of gotten a shoe in the door, and Kathy Rundle, the state attorney, gave me an opportunity. And what an experience. 4 years at the state. You're in court every day for hours at a time. I was able to try murder cases, drug trafficking cases, motions, bench trials. If you want to be a trial attorney, either the public defender's office or the state attorney is such an amazing opportunity. You just, unfortunately, don't make a lot of money, and a lot of people have debt. So maybe that's not a possibility. But for me, I was used to not having a lot of money at the time, and I jumped right into it, and I haven't looked back.
Fantastic. So you hit on something I think is really, really critical, and I don't think that we should gloss over it. You mentioned very early on there about finding meaning. And if you don't have meaning, I think that leads eventually to what we see a lot of times with lawyers is burnout. Because why are you doing what you're doing? It's not easy to be a lawyer, right? Especially a trial lawyer. And if you don't have a cause, you don't have a purpose, it becomes a real drag. And it's like, why am I doing this every day, every day? But if there's a goal in your mind and a purpose and it fulfills you, that keeps you going. Would you agree with that?
100%. And, I never take for granted the fact that when people come and seek my help and guidance, it's typically with some huge issue in their life. Whether they're being sued or they've been seriously injured, it's all the person thinks about. So, I realize that if they're going to come to me and trust me to take on that problem, then I need to give it 110% of my attention and really care. I think that's the one thing that when, my friends and family who are closest to me know that sometimes I can get a little too emotional and I have to pull those strings back a little bit, but it's ultimately because I care. And I realize that I'm not perfect. My presentation is not always perfect, but I think people always walk away through mediations and trials saying, that guy really cares about his client. You can feel the emotions, the frustrations through Ivan on what his client is feeling. And I want people to leave the mediation room or the trial room. Obviously, I don't do golden rule violations, but putting themselves in the shoes of that individual sitting over there and experiencing what they've been through. And if you can do that, then more often than not, I think you get the result, even from adjusters who deal with this every single day. I've had several adjusters call me after a settlement and say, we really liked your presentation. You were so professional. Oftentimes we talk to lawyers and they're rude and mean, and you were kind and respectful and professional. What's up with that? And I said, well, if we go to trial against each other, you may not feel the same way. But before I go to trial, I'm always professional. I always try to be likable because people oftentimes tend to give to people they like, right? Not saying best friends, but I don't try to just come in there and be a pit bull and be arrogant and egotistical. I really try to understand all the sides and realize that just because a case doesn't settle at mediation doesn't mean it won't settle shortly thereafter, which in my experience is oftentimes what happens.
And this is a people business. So you hit on that.
Mhm.
And also you hit on the fact of how you are interacting with your clients. They may have been going through something really, really bad if it's a personal injury case. And it goes without saying that some of our titles are attorney and counselor at law,
Mhm.
right? Those seem to be two different words. And so we are one, an advocate, two, we're helping our clients as a counselor. There's two roles, right?
I would say the counselor role is probably bigger than the advocate role, right? I mean, we don't have a lot of opportunities to be in court arguing motions, depositions, and trials doesn't happen all the time. The speaking and communicating with the client in the counsel role happens on an almost daily basis. And for, just kind of some more background, I mean, I have a small boutique trial law firm with my wife, who's an attorney as well. We met at the state attorney's office. And, how do we compete or differentiate ourselves against some of these bigger personal injury firms? And the only way we can do it is just by offering that personal service where, our clients become our friends, especially the personal injury ones, and they're texting us on a daily basis. The compulsory medical examinations that I know you know this, Patrick, but for people who don't, that's where the other side is allowed to hire an expert to evaluate our client in person. And a lot of times the client will go, to that doctor's appointment on their own, not with us. We accompany the client and we video record that meeting because I'm going to use that when I later depose the expert and realize that they probably haven't looked back on this file for 2, 3, 4 months. I'm going to be way more prepared than them. And more importantly, I'm going to show the client that when I say I'm going to be with you every step of the way, I'm going to be there at the doctor's appointments, the CMEs that I could be at. You're going to have my cell phone and text me. And I want you to tell me each week how you're doing. Some weeks are better than others, but I need to be in the know so that by the time we get to mediation, the work has already been done and I can express everything they've been through because of everything that we've discussed over the last 3, 4, 5 months.
That's really, really powerful and important. And I guess so. At a certain extent, you describe your philosophy as every case is personal, every case is unique, and every case has a clue waiting to be found. Tell
Yes.
me more about that.
Well, I mean, I'll give you an example. We had a recent elevator accident case at a beautiful hotel up in Broward County, and the elevator was malfunctioning over and over. We had records showing this, but we couldn't really understand what was the cause. And so we hired an expert to do an inspection. Okay, so they go and they got on top of the elevator. And as he's inspecting around and dusting off the little, uh, they have these like little filings that tell you when the service was done, when the permits were pulled. It showed that it was only for, I believe, like 4 elevator ropes, but there were actually 9 elevator ropes that the expert was seeing. So what is this? This is a little clue. We got to dig deeper. Explain why there's a plaque for 4 ropes. Now we're seeing 9. And lo and behold, what we uncovered was a year earlier, this hotel did massive elevator renovation work without any permits. Completely illegal, completely dangerous. And so our case turned out from what they believed was a small elevator accident, nothing to see here, into us basically being forced from a safety standpoint. The expert contacted the Broward Elevator Safety Office, who then came out to the building, cited them, and now not only did they have to resolve the case with us, but they had to fix the elevators and make them more safe and up to code for the thousands of people that were using them on a daily basis. And that's one of the really cool things about personal injury cases is not only getting a great result for your client, but getting a great result for the community, because now you're making these places and these businesses much safer. And had we not dug, had we not fought to get that in-person inspection, they would have hid this from us. And the jury, the potential jury, would have never gotten the full story of what's going on here. This wasn't just a random elevator malfunction. They knew this was going to happen, but they took shortcuts to save money. And this was a 5-star hotel. So it just goes to show you this wasn't something we were anticipating when we got the case, but when you keep digging and you keep looking and you keep searching, you find all kinds of clues that, blow up the case and you get punitive damages. And now the case value has increased exponentially.
And not only that, that would be for your own individual client,
Sure.
but your role also is providing a proactive safety approach for the future because
100%.
you're hopefully preventing another accident or worse one, given that they now need to make those repairs and bring it up to code.
You and I live in this community, just like the jurors. We take elevators every single day. And when you and I get inside that elevator, we trust that elevator owner has followed the law, has done his annual safety inspections, and everything is up to code, especially in some of these beautiful buildings on South Beach and Brickell that you just assume, oh, it's so nice. But then you start digging. And I hate to say this, but unfortunately, especially with elevators, we're seeing a lot of safety code violations that are not being addressed the way they need to. And that's where we get to come in and play the role of hero for the client, but also for the greater good of the community.
Well, pivoting to that, you mentioned your investigators, but you also say that you have an army of investigators. So most lawyers rely upon what their client tells them. Why is this personal investigative approach so important to what you do?
You're going against an insurance company with unlimited resources. They're going to have a team that's going up against your client, looking into every social media post they've ever made, any activity they've ever participated in. And in order to combat that, you have to assemble your own team of experts in the personal injury world, especially in premises liability cases, right? I'm not an expert on elevators. And working with a team of experts, not only do I get important evidence, but they help guide me through the process. I have an elevator expert that I've sat on the phone with for 3 to 4 hours and gone through the elevator code just to try to understand what all of these things mean, because I have to, in a sense, become an expert for that case. So I use all these resources to my advantage. And, it's our team versus their team. And the one thing I know, Patrick, versus an insurance company that has hundreds more cases than me, is that I have more time and I can pay more close attention to detail. And I can work more closely with our investigators. They have a Rolodex of investigators. Okay, let's use this for this case, send them out there. But there's not as much communication between that side, the insurance defense side, and the experts as you'd believe, mainly because there's not enough time. They're on to the next case, on to the next case. Whereas when I come up to an inspection or a deposition, I'm spending the 4 weeks before that preparing, looking at this from every angle. So when I get that deposition, which for all intents and purposes is the trial, right? In the civil world, I'm prepared and I get the sworn testimony that I need that I can then show at the mediation. And it's very hard to rebut sworn testimony, right? So that's how, whether it's premises liability experts, whether it's medical experts, whoever I need, if you step into this realm, you can't shortchange the cost. These cases do cost a lot of money. And I understand that's sometimes a hesitation for people. But if you work the cases up properly and you invest the money that it takes to really dig into the facts, then I believe you can get some very successful results, even when you're a small, little measly law firm like Abrams Justice here. A lot of times people may underestimate us, or maybe they haven't heard about us. I don't take it personally, Patrick. I see that as a great opportunity where they don't see me coming. And then all of a sudden after the deposition, they know who I am. And they can tell very quickly, are you one of those lawyers that will go the distance and really fight the case and go to trial? Or are you one of those lawyers thinking about your deposition tomorrow and just kind of going through the motions? And I try to make it very clear that I'm the former.
Very good. So I want to shift gears for a minute and talk about a specific moment. Typically, every lawyer has one of those moments, a case maybe, some sort of an event that changed the way they think. So I call this the defining moment. And the question is simple. What's the one case, negotiation, or moment in your career that fundamentally changed how you think about persuasion and advocacy? You don't have to name names. Just walk me through what happened and what it taught you.
Yeah, well, so I'd have to say there's a few moments. I mean, the first moment when I look at my career defining moment was having the courage to go out and lay my own shingle in 2013, coming from the state attorney's office, never having worked at any other civil law firms, having no mentors, not really having, a Rolodex of clients waiting for me. But I was confident, and I knew that if I could find a way to get the cases, that I had done the legal work in court, and I had gone against all these great lawyers, which, by the way, I've learned so much from the lawyers I go up against. Some good things, some bad things. And throughout that experience, I always take notes. In fact, I would go watch trials during my lunch break when I wasn't in a trial myself and learn from some of the best. There's one particular lawyer at the state attorney's office, a guy by the name of Andrew Edwards, and he was incredible in that he would come to my office and we would kind of practice telling a story to a jury. And I would start to explain to him my story. He would stop me there and say, that's not resonating. You're not getting to that emotional level. And so he really taught me how to speak, very frankly to a jury and be authentic and have that confidence. And then it translated through some cases. I mean, I had one particular case with a violent career criminal who had broken into multiple homes and, ransacked the place. And this guy, if he was convicted, faced 40 years in prison. And the jury, and he was actually a pretty likable defendant. But the jury was even crying throughout the trial because his kids were in the courtroom. So I had to deal with the fact that, there's real jurors, real people. This guy was likable, even though he did horrible things. And so how do I kind of deal with those two issues? A jury wasn't going to feel good about sending this guy to prison, even though what he did was wrong, right? And so I just had to confront that head on and explain to the jury that maybe they won't feel good about the decision they make. Convicting someone of a crime typically is not a feel-good moment. There's not going to be the confetti that comes out from the ceiling and the bottles of champagne pop. There's not going to be celebration. It's going to be quiet in the courtroom, once the verdict is read. But when they walk out of that courtroom and they go home at night and they're speaking to their significant others about the facts of the case and whether they followed the law, they're going to sleep good knowing that they made the right decision, even though it doesn't necessarily make you happy. And like I said, several jurors were crying when the verdict was read. So it's those kind of moments where you don't shy away from the elephant in the room. You have to address it head on. And through lawyers at the state, lawyers I've watched over the years, that's the one thing I've learned from the best trial lawyers is they don't sugarcoat anything. They don't ignore bad facts. They deal with it head on, and they look at every single juror for at least a minute or two and speak to them directly. So that's one thing that, I've taken. So opening my own shingle, getting all that trial experience. And then one thing I love in my own practice that I've done on a few occasions is be brought in last minute as lead trial counsel on a case, right? Because now the odds are stacked against you and you're being asked to kind of come in and play the savior role when you didn't get to take the depositions, but to present it to a jury. And I just had this experience in December with a friend who was in a 3-year dragged out contract battle. Both sides filed claims, fraud, breach, everything. It was a war. And then all of a sudden, here comes Ivan Abrams, last second, no one's heard of this guy coming into the case. And our client won on all claims. And the claims against him, he was found not liable. And the reason why we won that case, Patrick, was the jury selection. Going back to what I talked to you about before, we had an amazing jury, right? Miami jurors is a diverse pool, but I literally went through with every single juror because I got to go second. And I looked at their background biographical information and I said, where do we have a common connection? Where's their, either a place they've traveled to, or their son's a lawyer, or they live in Pinecrest, close to where I live. Where can I find that connection? And I went through every single juror, and I went through that common connection that we have. And I'm telling you, after that moment, when those jurors sat down, and I recalled them from jury selection, I knew as long as we were honest and had our credibility, the case was won. Because they are looking for which lawyer can I trust, which lawyer can guide me through the process. And I try to come off as not just a lawyer, but a regular individual who, has young kids, who works hard and, tries to do the right thing on a daily basis. And that really resonated and that stuck out to me with the jury. And I had a couple jurors that, weren't happy about being there, and they made that very clear. And I accepted that. And I told them, to be honest, if I were in your shoes, I probably wouldn't want to be here either. There's a million other things that you could do. Whereas the other attorney, you could tell he didn't really know how to react when some of these jurors seemed a bit pissed off and frustrated to be there. But I mean, that's completely understandable. And so when I'm telling them, oh, I understand how you feel, I'd kind of feel the same way. They're looking at me saying, there are honest lawyers. They do exist.
Well, that's remarkable. And I think what you described, the whole thing, and there's a lot of good nuggets in there, is at the heart of what makes a good trial lawyer and negotiator. So let's talk about your specific toolkit.
Mhm.
So I call this segment the Mediator's Toolbox because I think persuasion and negotiation tools that elite trial lawyers use are exactly what dispute resolution professionals need to understand. So, what's in your toolbox? Walk me through 2 or 3 techniques that you think every negotiator should have at mediation.
Well, kind of like piggyback on what I said earlier, actions speak louder than words. So before you ever get to the negotiation table in a mediation or just in a transaction, you have to do the homework. You have to be prepared. And the other side has to know that. Because if they know you're prepared and they know what you're talking about, it resonates. Now you have credibility and they realize they're dealing with, a real player here that they need to take seriously. So I think preparation, like everything in life, is key. And
Mhm.
every mediation is different. I wish that I could say that I always kind of use the same 3 tools, but I don't. I always realize that every case is different. The kind of, whether it's a breach of contract case or it's a personal injury is going to dictate the type of style that I use and the type of impact and emotions that I hit. So I would say number one, preparation. Number two, I think the one thing that is in my toolbox that I don't see all the time is passion, is speaking with passion so that you care. And like I said, maybe sometimes I get carried away and get too passionate, but I would rather have that than the opposite and be kind of monotone and not really care. Because I know it's easy to do that, especially for the defense side when they have so many cases and they've done 3 mediations. Half the time it looks like they don't want to be there. And I want the adjuster to show again that I want to be there. There's no other place I'd rather be than at that mediation. And they have my full attention. And I try to make sure that all the information that I have is given to them well in advance. I also really try to speak to the mediator in advance of the mediation, because I just think it's important that if you're going to ask a mediator to step in and, for example, do the job that you do, which is not easy, you have to be prepared with all the facts, all the details that you just can't get from just a pleading, right? So I know, for example, Patrick, you always set up phone calls. And the one thing that I've loved that you've always done is that you offer to stay in touch and follow up after mediations. So I would say that, number one, preparation, passion. And then the third thing is likability. I want the other side to leave saying, I realize we're on opposite sides of the V, but man, he's not a bad guy. Like, I like that guy. I like his presentation. I like his style. And I think that they will take that back to the powers that be. And more often than not, that results in a settlement. And the last thing I want to say on this, Patrick, and you, I'm kind of curious to get your experience. At least for the last 2 or 3 years, my experience is that most of my cases, personal injury, have not settled at mediation, but they've settled a few weeks after mediation because of mediation, right? So I go into the mediation with very low expectations, not expecting a settlement, but to get the conversation started. And I think once I've kind of, when I first started out, I was so excited the night before a mediation, we're going to get the big settlement and the client. And if it wouldn't happen, I'd be so disappointed, right? Now I've come to expect that it's a process. And the mediation, from my standpoint, is really opening those lines of communication, sizing up the other side so that after the mediation, they can go back to the powers that be and get whatever settlement authority they need. And then if you have a mediator that's willing to stay in the game and stay in contact with both sides, the mediation continues. And then the case settles a few weeks after and the client is happy. So I know it's kind of a long-winded answer. I apologize. But there's just so many different components that go into it, all starting with preparation, being authentic, being passionate, preparing your client. And I think if you do those things, if it doesn't settle at mediation, oftentimes it settles shortly thereafter.
Those are very good, I would say, ingredients. But the key component here is if both sides do it,
Mhm.
you're in a much better position to actually settle at mediation. It takes 2 to tango. And if one side comes in like you, Ivan, but the other side either doesn't have enough time, is disinterested, maybe doesn't want to settle, whatever it may be, there's a disconnect, right? And you're not going to get real far. And maybe that information will have to be conveyed later. And then maybe after mediation, you can do it. But I always try to impart to participants that mantra that you have. If you both do it, you're in a much better position to settle.
And, from a strategic standpoint with mediation, I was saying, give the other side all the information that you have ahead of time. Sometimes that's not possible. And let me give you an example, because I think people like examples. I recently had a personal injury case that was going to mediation. And the night before the mediation, they then hit me with the compulsory medical examination report, right? Which is obviously heavily skewered towards the defense. So when you drop a report like that on me the night before the mediation, I know you're trying to send me a message that, number one, there's a good chance it doesn't settle tomorrow. And if it does, it'll be for a very small amount, right? That's why you'd hit me with a report the night before that you've had for 2 weeks. But rather than getting upset and, getting all emotional and angry and saying you're wasting our time, blah, 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 I read the report in detail. And what I found is that the doctor either didn't have all the medical records, it was incomplete, or she had them and was ignoring the medical records because her opinion was based upon an incomplete set and some very important facts that were missing. So because they did this to us the night before, rather than going into the mediation and explaining to them how bad their report was and how there's all this important facts missing, in that situation, I felt the best strategic thing to do was to tell the other side that I don't think there's a chance that we settle today based upon this report. There's just a clear difference. And I think what needs to happen is we take a break, we adjourn, pause the mediation. You allow me to take the deposition of the expert next week, and then we come back the week after to continue the mediation, right? And so they were like, okay, sounds good to us. We do that. I take the deposition, and I ultimately confront the expert with all these medical records that she's claiming, oh, she must have overlooked it, she didn't see it, and she admits to me that based upon these records, her opinion would in fact change. So what do you think happened when we went back to the mediation a week later? Okay. And now we had this sworn testimony that I ordered the transcripts, and of course the case settled for 3 times what they wanted to settle. So I could have gotten angry. I could have, tried to explain to them during mediation why their expert is so stupid and doesn't know what they're talking about. But in that situation, it would have tipped off the other side to prepare the expert for what was coming. And so, I actually told the mediator I can't really get into the details of what I told the mediator, but the point is that the mediator knew there was evidence out there that we didn't want to share with the other side, and he was willing to keep that confidential and said, we'll deal with it when we come back and the case resolved. So that's where I think, again, every situation is different. You got to think on your feet. Sometimes share all the information, but if the other side is engaging in gamesmanship, don't get angry. Play chess, not checkers. So that's what I think I did in that case. And when you see something, I knew what was coming in the depo and I wanted to say it during the mediation, but I held back and it worked to our advantage.
And that was hard though, right?
Oh,
not easy.
No, my wife tells me all the time, Ivan, sometimes you just need to be quiet and stop talking. And it's easy some days and harder other days. And they're telling me this expert report, you can't get around it. And I'm thinking to myself, oh, wait till you see what's coming. But I held back and everything worked out. And then, when you tell your client this stuff in private and then they see it bear out, now you got a client for life, because now they're telling their friends and family, oh man, this guy explained all the strategy to me, all this evidence and depositions, and then it bore out in real time, which is, that's why I love being a lawyer. I know some people, some people aren't too keen on going to law school, becoming a lawyer. I tell everybody I meet that I love my job. I couldn't imagine doing anything else. And, just lucky to be in the position I'm in.
So how do you handle somebody at the negotiating table who is simply not being rational?
Well, I think again, you stay calm, cool, and collective. You don't get into an argument and lose your cool. I don't think that helps anyone. I think that's what they're trying to do, is bait you. And I think you stick to the facts. And you realize that with someone who's irrational, there's nothing that I'm going to say that they're just going to stop and say, you know what, Ivan, you're 100% correct. So don't take the bait. Stay calm, focus on the facts. And if you have to go back to the drawing board, a lot of times that's an act. That tells me, Patrick, that they don't have much. That's where all the bluster and the ego, and then you get the lawyers attacking each other and not focusing on the clients. Right? Focusing on themselves. And I always try to stay out of the sandbox and just focus on the facts and hit them with the evidence. And if they want to ignore it, then that's where my leverage is. Okay, I'll show this to a jury. I'll have a different response. And then typically I get a phone call from the adjuster, not the lawyer, a week or two later saying, hey, what do you want? What will it take? So again, ignore the sideshows, focus on the facts.
Fantastic. Now, what about this one? If a mediator could learn one thing from a trial lawyer, just one, what would you want it to be?
Whew. It's a great question. A mediator. Could learn one thing from a trial lawyer. What would it be? I would say the answer to that question would be to understand the dynamics and everything that the client has been through. Oftentimes as a trial lawyer, you're talking to the family, you're talking to the clients, and you spend so much time with them. And oftentimes they're never heard in the court system, the families and the other people that have been affected. And just like a mediator gets tons of cases, understand that the trial lawyer is in a very difficult position because they're the family's relying upon them. And so the mediator has to give that client the deference and respect that they deserve, and give the client, when you're in the private caucuses, the opportunity to kind of speak freely and vent to you in the same way they vented to us as counselors, because they don't understand the mediation process like we do. They don't really know the mediator like we do. And so sometimes they're a bit skeptical, like, oh, is the mediator for the other side, or are they on our side? And part of my explanation is saying that a mediator has to look at both sides. But I think a mediator that actually, when they come into a private room, rather than saying, Ivan, what do you think about X? Once I've told them, hey, feel free to ask my client any questions. I love a mediator that speaks directly to the client and really gives them a chance to get their feelings off the chest, because I don't think that always happens. And I know you do that, Patrick. And that's why I have so much respect for you, because regardless of whether the case settles or not, I feel like you always give all sides and clients a fair shake. And you always give the appearance that you've taken it seriously, that you've done the homework on the case. And that, just like I've said, this case is the most important in the world. I always feel like you give each mediation your utmost attention as if it's the only mediation you have. And that's what I really appreciate about you. And that would be my advice to mediators is give the clients an opportunity to talk to you.
I think that's excellent, because at the same time, they shouldn't be passengers. They should be participants. They're called participants for a reason. And you don't want to ignore them. You want them to be able to voice what it is that concerns them and ask them questions, make sure they know what's going on. And they are ultimately in charge, right? They call the shots.
I tell my clients before every deposition, you know the facts better than anyone else in this case. I don't care if the lawyers are puffing their chest, trying to trick you. This is your life. You've lived it every single day. So there's no trick questions when it comes to such personal questions. So just be honest and be authentic and tell them exactly how you feel, and nobody can impeach you with the truth. So that's one thing I always tell the clients to do. And just like you said, I always tell clients, especially now since so much is done via Zoom, come to the motion to dismiss hearing, come to the motion for summary judgment, come to the motion for punitive damages, because I feel like the client learns so much about the case and they see you advocating on their behalf. And even though litigation is long and time consuming, if they see that, they feel so much better. And, I tell my parents all the time that one of the things that makes me the happiest about my law practice is I've never had to withdraw from a case because a client and I haven't gotten along, or a situation where I haven't gotten paid, because I always take the time before I even take a case to really vet it and speak to the client in detail and tell them, hey, I'm going to expect you to answer my calls, speak to me every single week, go to court with me for hearings. I even have them sit in on the depositions as much as possible. Because again, this is opportunities for them to prepare. When you're listening to someone else being deposed, the client is sitting there for 4 hours and they're preparing for their depo. So if that's not the kind of lawyer they want, if that's not the kind of expectations they want, then I may not be the right lawyer for them. But I want them, we're literally going to war together in the trenches. And I can't tell you how many times I've had a client tap me on the shoulder in a trial or afterwards and give me great advice about the case. Because guess what? They're lay people just like the jurors, and they don't see things through the legal lens that we work with every single day. So I learned so much from my clients, and they know that. And I appreciate their cooperation and working with me every step of the way.
To wrap this up, Ivan, and it's been fantastic so far, but I know you got a couple extra nuggets for us. So I ask every guest this question. What are your top 3 tips for getting better negotiation outcomes? And these could be from the trial side, the settlement side, client side, whatever you think is best. But remember, they're focused on negotiation outcomes.
I think credibility and honesty. I think for the right case, the PowerPoint presentations have been great in mediations and negotiations to show the evidence and show snippets of deposition testimony. And then again, I think you need to show the other side what they can expect in court. You need to put on somewhat of a performance, if you will. For example, a lawyer that I recently resolved a case with told me that the adjuster and her discussed and said, Ivan seems like the kind of guy who probably goes out and has a cup of coffee with the client on a regular basis. And the answer to that question is I 100% do, because I care and I focus. And I think that is the end of the day is be yourself. It's similar. I told myself before this podcast, I was a little nervous, but I told myself, just like trial, be yourself, be authentic. Speak from the heart. And I think that's what I try to do in my negotiations is I don't go for gotcha moments, but I try to be an honest, credible player, but let the other side know that, hey, if you want to go the distance, then, I'm willing to take the next step and follow through.
All right. Very good. And for our listeners who are dealing with a serious accident case, a complex business dispute, or just need a trial lawyer who's going to fight for them the way you fight for your clients, Ivan, how do they find you?
Well, you can find me online. We have our website, www.abramsjustice.com. You can reach out to us at 305-709-0880. We get back to potential callers within 24 hours if we don't answer the line ourselves. And we always make ourselves available Monday through Sunday. If there's a problem, we're there and we want to help fix it. And we want to give that personalized attention and service. But I have to ask you one question, Patrick, because, I love to speak with you in our lunches in the past. I've learned so much from you. What is the one tip as a mediator that you would give trial lawyers going into a negotiation or mediation from everything you've seen?
I've kind of harped on this point for a while. I write about this. I do podcasts about this. I think the single most important thing is having the mindset of an intent to settle. Going into mediation doesn't mean that you're going to ultimately settle, right? But you have the intent, you have the drive, you have the preparation. I think that is the most important thing because that's a mind shift. You're not going there to litigate. You're not going there to discover. You're not going there to destroy the other side. You're not going there to play games, but you're going there to do legitimate business to try to settle. That requires different preparation, right? So you have to get all your ducks in the order. You have to know what the other side needs in order to settle. And then what? Give it to them in advance. These are kind of things that you already do, but I think that is the best thing because it's a mind shift. I mean, I was a trial lawyer and I see a lot of times mistakes that happen at mediation where people continue in the trial lawyer mode at mediation. And those are 2 different venues. You don't win a mediation, right? You don't. That's an oxymoron. You go in there, you both can win, but not one party. So you have to make it where both sides get something that they need and they have a reason to settle. So information sharing, giving them what they need all in advance so they can get it done. I think that's the single most important because all the other tips follow from that. When
one thing, Patrick, and maybe you agree with me, maybe some trial lawyers will disagree, but I believe that there should be 2 mediations required in every case, not one. Because I think oftentimes, the first mediation is an introduction. And like you said, it gets the parties into that mindset. Stop, the warring, the advocacy, and focus on a resolution. And I think sometimes that can be done early on in the case, right? To save costs for each side, try to get a quick resolution, which is in the best interest of the client. But I'd love to see a mediation be required right before a trial as well. Because I just think that, on the back end, when the parties are forced to come together and focus on that settlement mindset, magic happens. So I always try, if we don't settle it the first time, try it a second time. Yeah, there's costs, but it's a lot less than litigating for another year. So do whatever it takes to get the case resolved. And then I go to trial knowing that I did everything I possibly could to avoid this for the client. And now I feel like I have nothing to lose, right? Because if you force me to go do this, now I can explain to the client, we've bent over backwards, we've tried to settle and they've refused. And now we have to go to the last resort. And that's when the gloves come off and you get into trial warrior mode and the lion and all that good stuff.
I would agree, but I might have a slight modification to your idea. That
Please.
would be to do it earlier.
Mm.
Or have an earlier mediation, not at the very start. You need to have some information. But at the end of the day, how much information do you actually really need? Do you need everything to a certainty to settle? No, you're not even going to get that until you have a trial, right? So try to do it early, but prepare early, and then maybe have another one after, down the road. But don't wait to the eve of trial, because at that point, everybody's locked in. They've
Yeah.
spent a lot of money. They've hired all their experts. They have everybody ready to go. As we all know, preparing for trial takes a lot of time. At that point, they're like, we might as well go, right? So I
Yeah.
would say do it a little earlier. So your idea is great. Just move the timeline earlier.
And like, and I don't mean to take more time, but especially in the personal injury context, the mediation triggers all this internal discussions by the insurance company that doesn't happen until there's a mediation. So it really forces the insurance company, 30 days before mediation, they're doing the caucusing and the higher execs are looking at the file. So like you said, I think the earlier that happens and the cases are on the radar, the better chance you have of settling. Because I think part of the issues we run up to against some plaintiffs' lawyers is there's so many cases that they're focused on putting out the fire they're dealing with that week, as opposed to cases that are set for trial in 15 months. So if you have an earlier mediation, then you get on their radar earlier and you start that mindset and can hopefully settle it quicker for the client.
And worst case scenario, you find in that first mediation, you would gather from them what is it that they're missing? What is it that they need? You get it to them and you have that second.
Well, it looks like you and I have some
Yeah.
lobbying to do, but I'm all for it. I think the more attempts to resolve it, the better. Worst case, you're in the same position you were before the mediation, right?
For sure. So, Ivan, this has been an incredible conversation. Thank you so much for your time. I loved your stories and your insights. And for our listeners, if today's episode got you thinking differently about persuasion, negotiation, or what it takes to win at the table, please subscribe and leave a review and share this with one person in your network who needs to hear it. So until next time, we'll see you then.
Take care.
We hope you enjoyed this episode of the Meaningful Mediation Podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.